Yes, Mr. Ray.
Thank you, my Lord. To start with, if I might, Lord Stevens's question about the Bail Act and how that was dealt with, and I'm grateful to my learned friends, for having dug this out during the short adjournment, and no doubt somebody will supply a copy of the document itself in due course, but the answer is that there was a specific act, a separate act, to amend the Bail Act. It was passed as Act number 11 of 2011. Assented to on the 23rd of May 2011, which in the way that's required under the Constitution recites that it is or may be inconsistent with the Constitution, but nevertheless is being passed, and expressly provides there that bail shan't be granted to somebody who is charged with an offence under the Anti-Gang Act.
So is that passed under the special majority?
Under the special procedure that your Lordships, I know, familiar with. Section 13 of the Constitution have effect, even though inconsistent with sections 4 and 5.
Yes, thank you very much.
So we'll see to it that somebody sends a copy of that.
We have been sent it, actually.
Ah, good, right. So, my Lord, I was sort of midway through my submissions, although I think looking at the timetable, I don't propose to take anything like all of the time I've been allotted, because the argument so far has boiled things down to such an extent that I don't need to. Could I first of all just invite the board, just briefly in the context of getting clear the requirements of lack of reasonable and probable cause and malice. I invite the board to look at Williamson, which is in the authorities bundle. If you're using the electronic pages, it's 895 is the passage that I'm particularly interested in. That's, of course, a decision of the board from 2014, delivered by Lord Kerr, and paragraph 11 is just a useful recap of what one needs to establish to make out a claim for malicious prosecution: lack of reasonable probable cause and actuated by malice, significant challenge by way of proof. So the first part is about lack of reasonable probable cause, and then malice, secondly. Secondly, malice must be established. A good working definition of what is required is found in the Australian case of A against NSW. The dominant purpose of the prosecutor must be a purpose other than the proper invocation of the criminal law, an illegitimate or oblique motive. That improper purpose must be the sole or dominant purpose actuating the prosecutor. And then there's further discussion of that requirement, or further ways of putting that requirement, set out at paragraph 12. Prosecutor's motive has to be for a purpose other than bringing a person to justice, an intention to manipulate or abuse the legal system, and it's, according to the board in Crawford Adjusters, per Lord Wilson, a high hurdle for the claimant to pass.
So I think all that is consistent with the submissions you were making up to us this morning about
Yes.
the meaning of malice in the context of this particular tort.
Yes. And then 13 goes on to make the point that malice can be inferred from a lack of reasonable and probable cause, see Brown and Hawkes, but a finding of malice is always dependent on the facts of the individual case. It is for the tribunal of fact to make the finding according to its assessment of the evidence. And then there's discussion of what constitutes reasonable and probable cause, and that's the context in which we see the expression honest belief in the guilt of the accused, founded on reasonable grounds on the existence of a state of circumstances which, assuming them to be true, would reasonably lead any ordinarily prudent and cautious man placed in the position of the accuser to the conclusion the person charged was probably guilty of the crime imputed. And then the reference, I think, that your Lordship made earlier to Glinsky and McIver, Lord Denning. Not that there's a certainty of guilt, but there's a proper case to lay before the court. And then there's some reference to the facts of the particular case. And there's just one other reference I wanted to pick up from this judgment, which is at paragraph 17, which is about whether in that case that could be inferred that the prosecution was malicious. Second sentence, where there is absolutely no basis for suspicion especially where that is accompanied by an apparent reluctance to proceed with the charge, one might draw such an inference, but that was not remotely the position here. I don't, of course, say that is a legislative pronouncement and that in every case it's only where there is absolutely no basis for suspicion that you can draw the inference that malice was actuated the prosecution. But it's an important caveat to the suggestion that you can move straight from, or an important qualification to the suggestion that you can move straight from lack of reasonable and probable cause to an inference of malice. My Lord, just so I'm clear in the submissions I'm making, and I'm sorry if I perhaps to some extent am repeating myself from before the short adjournment, but so far as the question of admissibility of evidence is concerned, my respectful submission about that in connection with malice is that, well, first of all, one needs to be rather careful with how one deals with it, but essentially, of course, I would accept that if there is absolutely no admissible evidence capable of proving the charge, and the prosecutor knows it, but nevertheless prosecutes, then one can readily infer that the prosecution must have been malicious, because ex hypothesi the prosecutor knew that this could not result in a conviction. So the motive must have been something else, perhaps just to put the defendant through the hassle of being prosecuted because he deserved it, or whatever, in the view of the prosecutor. And likewise, I think I'd accept, insofar as the prosecutor has addressed his or her mind to the question, but just says, well, I don't really know, I don't really care, or the question has occurred to the prosecutor, but the prosecutor says, I don't really care, or if one can infer that, I don't really care, that is, whether there's any admissible evidence or not, then likewise one can readily infer malice. But the mere fact that the prosecution is brought in circumstances where it is later found there was no admissible evidence to support it does not by itself justify an inference of malice. It might, on the right case, if accompanied by other matters, perhaps, but that would depend upon the particular facts of the case. And my Lord, the other general proposition that I would seek to make is that a finding of malice.
Sorry, just on that.
Yes.
I mean, here on the judge's findings, there's a pattern of fabrication of evidence by PC Phillips.
Yes.
So why is it impermissible for the judge to infer from that he doesn't have any honest belief that, aside from his fabrications, there is or was material to be put before the court?
Well, may I come back to the answer to that question? I will deal with it directly, just after I've just dealt with one further general proposition, which in a way relates to that question anyway, right. which is simply this, that if one is going to find that a prosecution has been actuated by malice, then one is making a serious and damaging finding, and one ought to have evidence that is appropriately convincing in order to make it. It's really the high hurdle point.
But the high hurdle is just describing the difficulty about proving a negative. It doesn't change the standard of proof, which is on the balance of probability.
Of course, my Lord, of course I agree with that, and it's not. I'm not, I hope, guilty of the heresy of saying that there are varying standards of proof depending on the seriousness of the allegation. But of course, as I don't need to tell your lordships, that it's equally the case that the extent of the evidence that will satisfy a court that such and such thing is probably true varies depending on the context. And where one is making a serious allegation like this, then in my submission it ought to be backed up by solid evidence. But I'm guilty of not giving a direct answer to your lordship's question, which I ought to give. So let me do that without further delaying matters. The answer in my submission, my Lord, is that if one actually analyses closely the way in which the learned judge decided the matter, what her ladyship did was, first of all, not, as far as one can see from the judgment, to consider the possibility that the buttressing, strengthening, and fabricating of new evidence, of which she found the complainant, P.C. Nichols, guilty, might or might not have been the result of a lack of belief in the original in the guilt of the claimant. In other words, she seems to have jumped straight from the proposition that PC Phillips, lied in his evidence and said things there that he did not believe to be true, in other words, to the proposition that therefore he fabricated the case against the claimant. That's essentially what the judge says at the top of page 272 in paragraph 47. He starts by saying the inconsistencies in the evidence all relate to the important issue of whether there was reasonable and probable cause to charge the claimant and whether PC Phillips could have had an honest belief in the guilt of the claimant in respect to the offence for which he was charged. The fact that this officer throughout his testimony attempted to buttress, strengthen and fabricate new evidence against the claimant is a strong basis for concluding that he fabricated the case against the claimant and that in fact he had no reasonable or probable cause to charge him. I also form a view based on the many lies and inconsistencies in his evidence that the prosecution of this claimant was malicious in that there was an indirect or improper motive for proceeding with the charge against him. The possibility that doesn't seem anywhere to be contemplated, and in my submission ought to have been, is that notwithstanding the fact that there were lies, those lies didn't themselves mean that there wasn't an underlying basis for the original charge. In other words, the fact that PC Phillips lied in evidence didn't mean that when years earlier PC Phillips actuated a prosecution, he did so without any belief in the guilt of the claimant. It's simply a non sequitur.
But why is it impermissible for the judge to draw that inference? They've got a lying witness in front of them. It's being maintained that that witness did not have a proper belief that they were activating the court process in proper circumstances. Why is it not legitimate or permissible for a judge to draw the inference as to their state of mind from the fact that they've told lies about it later?
Because witnesses lie for all sorts of reasons. Witnesses lie, as juries, of course, are routinely told. In criminal cases, witnesses lie sometimes to buttress a good case.
Yeah, so why do we assume that the judge doesn't have that well in mind when she draws the inference that she does?
Because the judge doesn't address it at all in the judgment. And while of course I accept that there's a degree to which the court, the appellate court, doesn't demand every element of the judge's reasoning to be spelled out in black and white and can make certain assumptions about the judge having reasoned in a proper way. In an issue as critical as this, in my respectful submission, if the judge was going to make the very serious finding that PC Phillips had set this process in mind, in train, when he was of a mind that actually there was no basis for it, or he simply hadn't thought about it, or whatever it was the judge was finding. It's not quite clear what the judge is finding, but if that was what the judge was going to say, then it ought to have been spelled out, and it ought to have been explained properly.
I actually wonder whether in the next sentence the judge isn't doing that. The fact that he was not prepared to rely on the information that he received that the claimant's wife was involved in the trafficking of drugs and gang-related activity lends support, in my view, to the conclusion that he either had no such information or that even he did not consider such information to be reliable.
Well,
so
yes.
that does seem to be, is this not right, directly addressing the informant issue and giving additional reasons, quite apart from the fact that the claimant has lied in, PC Phillips has lied in the witness box, giving additional reasons to support the inference that PC Phillips didn't think that the informant information was ever going to be deployed or was reliable.
Well, my Lord, in my submission, first of all, I would say that the judge doesn't spell it out, and I can see why Your Lordship says that that may be what the judge is saying at that point, but it doesn't. It's a slightly funny way of, if that's a plank of the judge's reasoning, it's a slightly odd way of putting it in my submission. Secondly,
I think it's saying, isn't it, the conclusion I draw is that either there never was any information implicating the wife, or if there was, even he didn't believe he could rely on it. Either way, he didn't have an honest belief that there was a gang in which he was involved, which was what the case was.
And I'm rather reading the words "no such information." he's using that as what happened or didn't happen in relation to the wife as a test for what PC Phillips thought about or didn't think about the informants generally. So either way, either he didn't actually have informants telling him these things, or if he did, he didn't think it was reliable.
Well,
Either way, isn't that a sufficient basis for the judge to draw the conclusion that he didn't have an honest belief that the criminal procedure could be activated properly?
Well, there are several answers to that in my submission. One is that the case doesn't, the charge of gang membership doesn't depend upon the involvement of the claimant's wife as a member of the gang.
No.
She's one of the putative gang members, but not the only one.
Yeah.
The second is that it's not in any event a fair summary of the evidence that the witness gave about why he didn't proceed against the claimant's wife. He was asked about why he didn't arrest her. It's page 158 in the record. He's asked what caused...
The claimant's evidence, do you mean PC Phillips' evidence?
Yes, sorry, did I say the claimant? I meant PC Phillips' evidence. Yep.
Yep.
He's asked about this, and he's asked what caused you to believe that she was part of the gang. Information, sir. Information. When you arrested the claimant on the 27th of August 2011, his wife was present in the house. Yes, she was. So since you had information that she was also a member of the gang, why did you not arrest her at the same time? And the answer, you can see here is, well, sir, at that point in time there were a lot of infants involved, meaning children, and I did not believe I had sufficient evidence at that time to arrest his wife.
But that's part of his evidence which has not been accepted by the judge. She hasn't accepted any of his evidence. So there's...
Well, I agree. Well, she said he's generally not creditworthy, and to that extent, I suppose I have to accept that she didn't accept his evidence in that sense. But she doesn't deal. The learned judge doesn't deal at all with that explanation, and it's not it's an explanation that gives, as your lordship see, essentially two reasons for not arresting her at that time, which is not quite the same thing as saying I didn't believe that she was a member of the gang. And in fact, if you look at how it goes on, you didn't even think you had enough information to arrest her for inquiries. Am I right? He says I could have, but...
Well, he contradicts himself. First he said I didn't believe I had sufficient evidence to arrest her, and then he says he did. A bit later, yes, I did believe I had sufficient information.
I agree, but he also gives the reason, which I think is quite plausible, that there were a lot of children around, so presumably arresting her would have involved arresting both her and the claimant would have involved leaving the children on their own.
Well,
I mean that's the explanation he gives
for children, really, frankly. But anyway,
well,
the other thing that causes me a degree of concern is the case you're making to us is that the judge impermissibly jumped to the conclusion of malice. And I assume from that you are leaving out the intermediate stage, and that was that PC Phillips was completely incompetent, and incompetence is not malicious. And that is, in fact, the case that the Court of Appeal based their judgment on. Was that case ever made, at first instance, to the judge, so that it was an issue that she had to decide? So, by the way, in the alternative, PC Phillips wasn't malicious because he was just completely and utterly incompetent.
A fool, not a knave.
I don't think so. I'm rereading the closing submissions of the defendant to see whether it says that in those terms. I very much doubt that it does. I'm sure I wouldn't have forgotten it if it does. But
is it terribly unfair? Is it a bit unfair to criticise a judge for not deciding an issue that isn't put before him?
No, I think it's fair to say, my lord, that the way the case was put before the judge was fairly and squarely that there was reasonable and probable cause to prosecute, and the prosecution wasn't malicious because it was done on the basis that there was such evidence, and that's why a prosecution was advanced. But I'm not sure. I would respectfully submit it's not altogether fair to criticise the defendant for not advancing a case at trial that this was incompetence.
No.
Explicitly, but that's plainly a possibility that a court ought to bear in mind in circumstances where it's being. I mean, if one thinks about any case where a party is accused of dishonest wrongdoing, I mean, either the court is right to accept if the claimant succeeds. So take a straightforward civil fraud case, and the claimant succeeds. I mean, either the court is right to accept the allegation of fraud, or it's wrong to do so.
Yeah.
And one doesn't say, well, you didn't.
The full knave distinction is well understood to courts, judges, and so on. I'm not even sure that it's fair to criticise the judge for skipping over that question, because at the beginning of paragraph 47, she poses for herself the question, could Constable Phillips have had an honest belief in the guilt of the claimant in respect to the offence which he was charged? So, I mean, she's posed the question in terms of honesty, and she's concluded, no, he didn't have that honest belief. I mean, doesn't that comprehend going through, in her own mind at least, dismissing the possibility that he acted through incompetence rather than genuinely because he was dishonest and did not have an honest belief?
Well, I suppose implicitly it does, and it would have been better, I think I would submit, if the judge had positively considered the incompetence angle, but I accept that it's difficult to criticise her for doing so in circumstances where a case wasn't advanced. This was just incompetence. But in my submission, that aspect is something of a distraction, because it's
I've certainly got no difficulty with the concept in a criminal trial that the judge has an obligation to sweep up the alternative cases that have not been made. But I just really wonder whether or not that's the obligation resting on a judge in a civil case.
Well, I also wonder respectfully whether your lordship's question doesn't elide another possibility, which is simply that it doesn't ignore the existence of another possibility, which is that there's a simple error. One doesn't need to get into the question of whether this was incompetent on the part of PC Phillips. One doesn't need. One can imagine that a defendant at trial might run a positive case, theoretically, I suppose, maybe in respect of a former officer, perhaps in a hypothetical case. Well, this was a totally incompetent officer. I mean, imagine a case where actually there were several instances of the officer behaving incompetently and he'd been got rid of. That might be, in an extraordinary case, you might imagine a defendant running a positive case of incompetence. But leaving aside that possibility, the real question was whether there was an honest belief in the guilt of the claimant or not, or rather whether there was malice in respect to the prosecution or not. And an obvious possibility that did need to be considered was whether this was simply an erroneous judgment. That didn't require a positive case to be run that this was incompetence. It just required the court to address the question as to whether the only explanation for the fact that there was a prosecution was brought without reasonable and probable grounds was malice, because that was the claimant's case on the pleadings. We make the point about this in our printed case. On the pleadings, what's said is simply under the heading particulars of malice, it's the absence of reasonable and probable cause. So that being so, it did, in my submission, fall to the judge to consider whether or not actually the explanation for this was simply an error on the part of PC Phillips, and not simply to jump, as I respectfully submit the judge did jump and wrongly jumped, to the conclusion that because there was no, or from the conclusion that there was no probable cause, and from the conclusion that he'd fabricated the oral evidence that he'd given, to the conclusion that there was malice. My submission that wasn't open to the judge to do. Well, there's another aspect in which, in my submission, the judge's reasoning is deficient. That is that it doesn't take any account at all of, and this is really, it's connected to my point about jumping from the dishonesty of the oral evidence that was given to the conclusion that there was therefore fabrication of the case against the claimant. It doesn't take any account of the document at page 88, which is the contemporaneous document. And just to set that in context, my Lord, that is the document exhibited NP4 to PC Phillips's statement. Page 52 takes you to the relevant passage in the statement. Paragraph 15. He said in his statement, on or around 10 a.m. on the 29th of August, when the exercise was concluded, there was a debriefing exercise. Notes were made. Based on these notes and the information I'd gathered, I later typed my notes and signed it. A true copy of my typed statement is attached and marked NP4. That evidence wasn't challenged, and the genuineness of this document wasn't challenged. If one then goes back to 88 to look at the document, one can see at the bottom that it's dated, I think, either the 1st or the 9th. I think it's the 1st.
And when you say the genuineness of this document wasn't challenged, I think aspects of what is said in the document were challenged.
Oh, yeah, yes. I mean, what I mean is it wasn't said to be, you just cooked this document up for the,
right.
you did it last week just before the trial.
Right.
My point is, what wasn't an issue was that this is what, long before anybody was talking about a malicious prosecution, this is what PC Phillips sat down and wrote.
After the charge had been dropped?
No, after the charge was made.
After the charge had been made, before it had been dropped.
Before it was dropped.
When was it dropped?
First, it's
The charge was dropped at the end of September. This is either the 1st or the 9th, depending on.
Okay.
It's more likely to be on his evidence. It's more likely to be the 1st because he said he did it shortly after the 29th of August.
Right.
Right. Okay. In fact, to investigate, it looks like the 9th of the 9th, but I'm not sure it particularly matters.
Could be either.
And so the first bit he puts in is that he conducted interviews with those persons arrested and received information on the defendant's involvement in the narcotic trade. Well, that's one element of a gang, but it's certainly not that he was involved in a gang.
Well, Lord, he goes on to say, I mean, if one sets it in context, he's talking at this stage about a significant period of time, December 2010 till the present. So that's the period during which he's arrested several persons and conducted interviews with those persons and several other persons.
But the first 5 or 6 lines doesn't say he's a member of a gang.
No, I agree.
And he says that his nickname is Peck. And then he goes on to say that he had tried to apprehend the subject who managed to elude capture.
But he does mention that he was selling narcotics, he believed, with Kerwin Rock. So
Yes.
That is,
Yes. So that my submission plainly is gang activity if it happened. So
I'm not sure that this document helps you particularly because some parts of it, as I understand it, the judge has found to be dishonest fabrication. For instance, the attempt to arrest the claimant and he ran off. Is that in here?
Yep.
So that's one of the parts of his evidence that she did not believe. So it might be said that actually if you read back those findings to this document, it bolsters the case of malice because he was trying to put it forward at the time as something to justify the arrest, but it's not true.
Well, the problem with that is that the learned judge doesn't, in her approach to the evidence, because she takes this rather, I would respectfully say, rather broad brush approach of just saying, well, he said lots of things in oral evidence which I found unconvincing, doesn't actually address the existence of this document.
And all of the Court of Appeal, do they?
I don't think they did, my Lord. No. But it's actually rather important contemporaneous evidence of certainly what he was saying at the time, long before, as I say, there was any possibility even of the charges being dropped.
But he's writing this document at a time when he subsequently states in court that he didn't see Mr. Kerwin Rock and and the appellant acting in union. doing anything apart from having conversations with each other.
Well, that's his evidence as to what he saw, but what he says here is that he conducted inquiries which revealed that the defendant, Kevin Stuart, etc., known as Peck, sells narcotics together with a Kerwin Rock of Union Park East, with other persons who are yet to be identified. So he's talking there about the information that the inquiries that he's received, that he's done, and the information he's received from those inquiries. So,
motivation of drug dealers is to blame somebody else. So your informant has got whoever it is, has got a massive motivation to pass a buck onto somebody else.
Well, my lord, yes, and that may or may not be a reason in due course for either for a jury to reject the evidence of an informant or for a prosecutor to decide not to even try to adduce the evidence of the informant, even assuming the informant can be persuaded to give evidence. But none of that, in my submission, by itself goes to the point that, or goes to establish the proposition that if you prosecute in circumstances where that's the sort of information you're receiving, you're doing it in the base of, on malicious grounds. I mean, this is a document that's squarely inconsistent with the notion. I mean, it's not entirely clear what notion the judge had of this, other than that there was fabrication of the case against the claimant. But it's squarely inconsistent with the notion that the PC Phillips simply decided to bring this charge without having any even subjective basis in his own mind to bring it. And one of the
would it be fair to say that the Court of Appeal really substituted their impression for that of the judge when they, for example, found that she wrongly imputed that he had fabricated evidence? That was one of their criticisms.
Well, the Court of Appeal...
And then at the end, in paragraph 39, they have a sort of refrain about there was nothing to think that these weren't police officers who were motivated to apply the law fairly and bona fide, and PC Phillips conscientiously sought evidence, etc. I mean, really, that was just replacing the judge's view with an impression of theirs that everything that he'd said should be believed, really.
Well, I'm not sure that's entirely fair, my lord. The Court of Appeal didn't have in this case the particular disadvantage that the Court of Appeal sometimes has of a judge who has said, I base what I say upon the impression that the witness gave me giving evidence. So they were confronted with the same thing that your lordships are confronted with, namely the judgment of the judge, and that series of bullet-pointed inconsistencies and admissions or omissions, however the judge puts it, and the judge's conclusions. And so, in my submission, they were entitled to say that the judge had got that wrong. But what matters for present purposes, in my submission, rather more, is really what your lordships make of the judgment. Because if the Court of Appeal were ultimately right to reverse the judge, but did it for the wrong reasons, then that's really neither here nor there. If I persuade your lordships that the answer is to reverse the judge, then that's that.
Fair enough.
But my lord, I wanted to make this point about the judge's finding that there was an indirect or improper motive for proceeding with the charge. This is again paragraph 47 of the judgment. I accept, as I did before the short adjournment, that there is not a legal requirement on a judge who finds for a claimant in a malicious prosecution case to spell out what the improper motive was. But the absence of it does, the absence of doing that does, in my submission, make it all the more important that the judge's reasoning stand up to scrutiny. Because one does necessarily ask oneself, well, what is it being said then that the prosecution was for? Why was it being done?
Page 179, it was put to the witness.
It was put. I agree. It was put to the witness there that they simply rounded up. I think I'm summarising fairly, but simply rounded up everybody they could think of with a with a prior criminal record. But the judge doesn't deal with that. The judge doesn't address that issue at all. The judge simply says, well, there was an indirect or improper motive, but very unsatisfactorily leaves it unclear as to what it is the judge is finding. And there are other, in my submission, really fatal problems with the judgment. If one goes on to paragraph 49, there's already the last sentence which we looked at, or your Lordship looked at in the course of my learned friend submissions. No such evidence which could form the basis of an honest belief that the claimant was involved in gang activity was produced by the defendant. I mean, as a statement of what the evidence was, that's plainly wrong in my submission.
And what evidence remains that you rely upon?
Well, first of all, I don't accept that the judge either did, or if she did, that she properly did reject all of the evidence of the defendant of the PC Phillips in his witness statement about the existence of informants.
I'd be much helped by knowing what evidence remains after the judge's judgment.
My Lord, my difficulty in answering that question derives from the way in which the judge herself expressed matters. If your Lordship's reading of the judgment is that the judge rejects everything that was put in evidence by the defendant, then, of course, logically, the answer must be, well, there was no evidence. But that is not, in my submission, a fair reading of the judgment.
And so, if one takes a more balanced approach to it, what evidence remains?
Well, I'm not sure why your Lordship's inviting me to strike the balance. You say a more balanced approach. I mean, the evidence that
What was the evidence?
well, the evidence that was advanced. Perhaps I can answer the question more usefully and more helpfully to Lordship in this way. The evidence that was advanced, and I've set it out in our case at paragraph 20, page 442. It's the prior convictions. It's the information that was given on the 20th of August that the appellant had sold drugs and was a member of a gang. That's from PC Phillips's statement. It's the information on the 27th of August to the same effect. And it's the fact that PC Phillips knew that the appellant had the criminal alias Peck.
Well, I'm not sure that adds anything, does it? Because he must have got that presumably from the informant, unless there's anything else. Doesn't the judge really deal with that? Maybe not all that clearly, but she rejects the previous convictions in paragraph 49 as a basis. And then she's saying there's nothing else except information, and mere receipt of information is not enough.
Well, my Lord, I respectfully endorse the suggestion that it's not altogether satisfactory. In fact, it's highly unsatisfactory as the basis of a finding as serious as this. Because the first sentence of 49 seems to assume that what the question it's addressing now, I should say rather, appears to be, does that fact by itself form the basis for a reasonable suspicion that he was a gang member involved in the trafficking of narcotics? Well, that's not the issue. It's one of the features that I say led on the evidence should have been found to have led PC Phillips to his belief, correct or otherwise doesn't matter, that it was proper to set the prosecution in motion for gang membership. I mean, it's plainly a world away from a situation where it could be said, well, this is a person of good character, so what are you thinking here? But then the learned judge then goes on to say it was incumbent upon Police Constable Phillips, as instructed by Assistant Superintendent of Police Mohammed, to obtain evidence of the claimant's involvement in offences against the Anti-Gang Act from the date that it came into force. No such evidence which could form the basis of an honest belief the claimant was involved in gang activity was produced by the defendant. Now, I've already made the point that it's certainly wrong to say no evidence was produced, but there's a further error in my respectful submission, which is that the judge seems to be under the belief that there had to be evidence of criminal activity by the claimant in the period, or by the claimant in conjunction with somebody else, in the period after the Act came into force, in order for PC Phillips to have any belief that a prosecution could be launched. In other words, for it not to be malicious, for the prosecution to be launched. Well, that can't be right, in my respectful submission, because and this is why I took your lordships to the Act at the beginning of my submissions. The Act doesn't depend upon you doing anything.
Well, the offence is being a member of a gang.
The offence is precisely the offence is being a member of the gang, but that's not what the judge is talking about. She's talking about whether there were evidence. She says there has to be evidence of the claimant's involvement in offences against the Anti-Gang Act from the date that it came into force. And
well, that's right.
So when I ask myself, what does the learned judge think is meant by offences against the Anti-Gang Act? Well, the answer is being involved in gang activity. But the whole point of the Anti-Gang Act, as far as one can see from its face, is that it takes away the need to prove a specific instance of criminal activity. That's if you've got that, you've got the person anyway. The point is the offence is being a member of the gang.
But why shouldn't we assume that the judge understands that?
Because the judge's language is directed to the opposite. It's involvement in gang activity.
Well, paragraph 2, this is page 252, she identifies very clearly the relevant offence, which is of being a gang member, contrary to section 518.
Well, I don't dispute that the judge has accurately stated what the charge was, but what matters is whether the judge properly addresses what it was that PC Nichols, in order not to be guilty of maliciously prosecuting the claimant, had to believe was the case as regards the claimant.
She's making the point, isn't she? If you read the latter part of 47, where she refers to the Anti-Gang Act, and then read that in conjunction with 49 and 50, I think what she's saying is, isn't she, that to show that somebody's committing an offence under section 12 of the Anti-Gang Act, which is being a gang member, it's not enough just to have information. You've got to have something that would be capable of being used as evidence, and there wasn't anything.
Well,
you showed us the section which refers to admissibility and evidence, I think.
Well, the section talks about any
or the definition
anything which might reasonably lead to an inference. Well, rather than paraphrasing it on the hoof, shall I go back to it? It's page 905, I think. Any evidence reasonably tending to show or demonstrate the existence of or membership in a gang.
But does that mean admissible evidence? Because you showed us on 905 it's not necessary to show they have a sort of secret signals, etc. But they do need to show that there is demonstrate the evidence tending to show or demonstrate the existence of membership of a gang should be admissible in any action. So what's the reference? Sorry,
yes,
preponderance of other admissible evidence. It's trying to suggest you have to have admissible evidence, not just
all
information.
In paragraph 5. Well,
I think that's the point the judge is making, isn't it? That you need admissible evidence and not just some informer has come along and told you something you can't use.
Well, the section itself, in fact, says that you don't need to have any of those things, flags and secret signals and so forth, when the gang's existence can be demonstrated by a preponderance of other admissible evidence.
Yeah.
But any evidence reasonably tending to show or demonstrate the existence of or membership in a gang shall be admissible.
Right.
So it does set a very low bar for admissibility. As long as you can persuade the judge that a jury or a fact-finding magistrate could reasonably
I assume it wouldn't be
could regard the evidence as reasonably tending to show membership, then it's admissible.
Well, is it admissible to say, I spoke to unnamed informers who told me that he's a member of a gang? Could that be admissible in court?
Well, my lord, on the face of it, yes, but this isn't an exam into the correct meaning of the Anti-Gang Act. The question is, can we infer from the prosecution of this claimant by PC Phillips against this background that PC Phillips must have been actuated by malice?
I've never heard of any criminal trial in which there's been hearsay evidence from a prosecuting officer saying, by the way, I was told by blogs or somebody about something. That's why there's closed material procedures, so that you can actually hear that evidence in a different forum.
Well, my lord,
have you got any authority for the proposition that hearsay evidence of that nature coming from an informer is admissible in a criminal trial, or in any?
Well, my lord, it's not an essential part of my case to persuade the board that that is the correct interpretation of Section 5.5 of the Anti-Gang Act. What I merely observe is that on the face of it, that is very wide, and it does set a very low bar for admissible evidence. And of course, this is an act that is passed under Section 13 of the Constitution, which of course provides that the act passed under it can have effect, notwithstanding inconsistency with Sections 4 and 5 of the Constitution, subject to there still being further qualifications, which I know some members of the Lordship's Board are very familiar with in connection with the recent Suraj case. But for present purposes, we're not, of course, concerned to establish whether PC Phillips would have been correct or incorrect in deciding that information from informants was enough to get home on a prosecution under the Anti-Gang Act. The question is, can one infer from the fact that the prosecution would have, if it's right, the prosecution would only have been based on those informants. Can one infer from the fact that he set it in motion that he must have been actuated by malice? Well, my lord, the very fact that the question is debatable and requires citation of authority if one is to get it home, and requires consideration of the constitutional aspects and so on and so forth, illustrates the proposition I'm seeking to make, which is that one can't infer it from that. What we know is that the police were told about the existence of the Anti-Gang Act. There's actually a reference in the evidence, another piece of unchallenged evidence, that they were given a lecture about it. I'll just turn up the reference if I can find it. It's in one of the exhibits to, sorry, I've lost my note exactly where it is, but it's in one of the exhibits to PC Phillips's statement. This was put in under a hearsay notice. Yes, it's page 37 of the electronic bundle.
And did the judge admit this hearsay evidence or not?
I haven't found anything where the judge explicitly does so, my lord, but bearing in mind that it's found its way into the... I don't think objection was taken to it, and bearing in mind it's found its way into the record, I think we can assume that it was at least formally before the court.
I'm so sorry, which page are we on?
Page 37, my lord.
Thank you.
What one can see from this is that what the police were being told, police officers were being told in this lecture, to which these are the notes, was various information about the Act. And you can see there's a definition about halfway down, or just below halfway down, if a person is suspected of being a member of a gang, and the Anti-Gang Act defines a gang as, and it tells you what the definition is. We may choose to pursue a line of inquiry in that regard. Well, the point to which this all goes is that in my submission, this is a rather different case because of the context from a more straightforward case where, for example, the offence which the claimant is prosecuted for is a well-established offence in respect of which there are well-established parameters. Suppose the charge were robbery or murder or any of the well-known offences, and the evidence showed that all that was left that the prosecutor had to go on was information from anonymous sources, and there was no reason to think they would come forward to give evidence. Well, in those circumstances, it would be easier to infer from that state of affairs and the fact that the prosecution had nevertheless been launched that there must have been malice behind it. But that's very much not this case. This is a brand new piece of legislation which, as we've seen, has, although I don't say that PC Phillips himself, there's any evidence whether he looked at it or not, one can perhaps infer that he didn't, but has in section 5.5 a particular provision about admissibility of evidence. And what we know is that the prosecution went ahead and was then discontinued.
But this note actually tells you what you've got to do if you have somebody who may not be willing to attend court, which is to get a proper statement from them. And it's referring to section 5.5 in that context as well. This is page 38.
Page 38.
And it sets out evidence which may assist. And then it deals with a witness who's unwilling or fearful to attend court. It says what you've got to do.
Can I just inquire the particular passage your lordship's thinking of?
In those circumstances, regard must be had to the Evidence Amendment Act, a statement made by a person, etc., etc.
Yes. Yes.
So it's looking at a far more formal process than simply information received on the street.
Well, of course, I agree. It's more formal than that, but it's nevertheless a considerably more involved process. If one tries to think of it from the perspective of an officer who is presumably accustomed to dealing with the general repertoire of ordinary offences, here's a new piece of legislation. I nevertheless stick by my point that it's quite a different thing to say in these circumstances. You can infer from the fact that the prosecution wasn't in fact supported by reasonable and probable cause that it must have been done maliciously, and I do stand by that point in this context.
What was the date of the lecture?
I think we are told that in the hearsay notice. I think maybe we're not.
We're not.
I don't think we're told, actually. So perhaps I'm guilty of assuming this must have been put before the officers prior to the events we're concerned with. I don't know.
Did PC Phillips refer to this in his witness statement?
He did.
I don't think so.
No, I don't think so.
So
It wasn't put in evidence by him.
He attended this lecture.
No. I mean, I don't think I can rely on it. I don't seek to rely on it as being a bit of evidence as to what PC Phillips himself was told about it. But the point is that
You said he was briefed on the Act, paragraph 11, as far as it goes.
yes. Well, I suppose one can infer from that. But that's having having. Yes, he says, actually he does say, upon the coming into force of the Act. So on reflection, I think I will stand by my initial suggestion that one can infer that this was something that was presented to the officers when the Act came into force on around about the 15th of August. Well, it simply goes back to my point that there is, in this case in particular, even less reason to jump from the absence of reasonable probable cause to a finding of malice. And if the judge was going to make such a finding, then it was incumbent on the learned judge in our submission to do so explicitly, rather than in the way in which the learned judge dealt with it. And, my Lord, I think what I was dealing with a question from Lord Leggatt several minutes ago now. Now I've had that little diversion into the lecture notes about the last part of paragraph 47, where the learned judge refers to sections 12 and 13 of the Anti-Gang Act. I think the point that was being put against me was, well, if you read that together with what the judge says later in the judgment, you can see that what the judge is saying is that there must be at least admissible evidence. But in fact, sections 12 and 13, of course, are about arrest and reasonable cause for arrest, which is a different subject altogether. So in fact, in a sense, it's a point in my favour, I submit, that the judge talks about that in that context. It shows yet again that the judge is, as I respectfully submit, not properly and squarely addressing the question that ought to have been addressed here, namely whether there was actually evidence from which it could properly be inferred that the prosecution was actuated by malice. It's just not good enough in our respectful submission to say, well, the evidence that I heard orally I reject because it was full of inconsistencies and constituted buttressing, strengthening and fabricating evidence. That provides me with a basis for saying that the charge was fabricated against, the case was fabricated against the claimant. It's not even clear from the judge's judgment what the learned judge means by the case being fabricated against the claimant. Does the court mean that PC Phillips started from the basis that there was really no wrongdoing at all on the part of the of the claimant and just invented it altogether? Does the judge mean that he thought there was some wrongdoing but not the wrongdoing that was covered by the Act but decided to carry on anyway? Those are themselves quite different things.
I'm not sure that your criticism of paragraph 47 is entirely fair, is it? So the last sentence where the reference is made to sections 12 and 13, I take your point that those are concerned with arrest.
Yes.
And directly are concerned with reasonable and probable cause, because that's the powers of arrest are conditioned in that way. But isn't the point of the introduction, in any event, that the judge clearly does have in mind the two different cases which are being presented before her? One is wrongful arrest and false imprisonment, which turns upon whether there's reasonable and probable cause, and the other is malicious prosecution, which turns upon the state of mind of PC Phillips. So when she's been through paragraph 47 reasons why she regards PC Phillips as not having an honest belief in the charge which is brought, and then at the end she simply says, in any event, whether I'm right or wrong about that, the information without more can't support a case of reasonable and probable cause. She's got to deal with both in her judgment. Isn't that all that she's doing there?
Well, if that's the explanation, then well, so be it. But it doesn't. If that's right, then it can't. That sentence can't at the same time serve the purpose that I think Lord Leggatt's question implied, which is of all right, salvaging the reasoning in relation to in relation to malice.
Can I put this to you? I mean, it might be said that there are, if you like, three elements of the case which PC Phillips is putting forward as justifying his bringing of the charge. One is things that he has done and seen being done, so his own evidence about the involvement of the appellant in various ways. Secondly, there are informants, so what other people have told him. And third, there is the previous convictions. Now, so far as the first of those is concerned, it might be said that paragraphs 45 and 46 are the judge's answer to that she doesn't believe anything that PC Phillips says about what he has done. Paragraph 47, we've been through this already, the judge does directly address information received and gives reasons, quite apart from fabrication of PC Phillips' own evidence, why she can infer that he didn't believe or did not receive evidence from informants. And then paragraph 49 is where she deals with the significance of previous convictions. So what I wanted to put to you is, if one reads the judgment in that way, hasn't she dealt with all the matters on which PC Phillips was seeking to rely to support his honest belief that a charge could be brought?
Well, Your Lordship puts to me, with respect, a very skillful reconstruction of the judge's reasoning based upon what's said in the judgment. But each of those suffers, each of those elements, when considered in isolation, when each is put under the spotlight, suffers from, in my submission, irretrievable difficulties. I've said what I say first of all about the judge's bullet point approach to contradictions and inconsistencies, and her ladyship's failure to set out really a clear set of findings there as to what it was that was being said that was not correct and what was correct, and whether it was mistaken or dishonest. So far as 47 is concerned, I think I probably already set out my response to that as well, that there isn't there a sufficient basis for going from the conclusion that there were no there isn't a sufficient basis for saying that the informants didn't justify bringing a claim. In other words, by bringing the claim based on the informants, well, from the fact that the claim is brought on the basis of the informants, one can infer there must have been malice. That doesn't emerge properly from 47 in my submission. And 49, I mean, I agree that on its own terms it's dealing with the previous convictions, but of course what it doesn't do is to consider previous convictions in the context of the other evidence. The real question, which the judge never squarely addresses, and one can try to piece it together if one's trying to look at how it might be argued on the other side. Of course, one can try and piece it together from all the different elements, but what the judge really needed to do was actually squarely to address the ultimate question as to what she thought the motive actually was for bringing the charge, and whether on the evidence there was a proper basis for saying that the charge was brought maliciously, and that's never squarely addressed. And
Sorry, but is there a page where we have all his previous convictions? And if so, don't.
There is somewhere.
Yes.
There is. I'm just trying to find it. I won't take a lot of time if I can't find it straight away, but I think, yes, it's page 86, I think.
86, thank you.
Well, I think it starts on the previous page.
Right.
Yes, well, the previous page is a record of particulars of pending cases, I think.
Oh,
Although,
right.
in fact, when you look at that, that's what the headline says. When you look at
It goes back a long
yes,
way.
they just used the wrong form, I think, to fill in the.
Just his earlier convictions.
Does include earlier convictions as well. It's quite a long history.
Yeah, one can spend too long trying to scrutinise these things, but I wonder whether the page 85 is matters which have been brought to the attention of the police, and then 86 are specifically things of which he's been convicted. I don't know.
Yeah, there's no conviction date on the first list, is there?
And I thought the judge...
They're complaints, perhaps.
Yes, I think on
or
reflection,
arrests.
right.
Arrests, maybe.
I think the
Arrests on the first page, and then convictions on the second.
Yeah, so, I mean, Judge paragraph 6, page 254, 6 little 2. it was an agreed fact. Claimant had 3 previous convictions. 2 of these were for narcotic offences. That seems to correspond to page 86, I think.
Yeah.
Yes, thank you, Mr. O. Where do we go from?
I think we're we're more or less there actually, but I'm not sure I have a great deal more to say other than simply, Your Lordship, I'm sure I have the point. But so I say essentially what. Of course, one can go through the judgment and take bits out and try to piece it all together. But fundamentally, the judge's task was to address squarely the question whether, in all the relevant context, which includes the prior convictions, including for drug offences, the contemporaneous evidence of, in other words, contemporaneous from P.C. Phillips, I accept the contemporaneous evidence of his note talking about what he'd been told about by the informants, and all of the relevant circumstances, including the fact that this was a new piece of legislation where the only thing that had to be established was that you were a member, that you belonged to a gang, brackets, by adducing any evidence which reasonably established that proposition. Is it really right in those circumstances to conclude simply on the basis that P.C. Phillips told a lot of lies during his oral evidence, that therefore when he caused the prosecution to be brought under that new act, he must have been actuated by malice, abusing the legal system rather than for a proper purpose? My Lord, if one puts the question that way, which in my respectful submission is the right way, then one can see that the conclusion that the learned judge came to in the claimant's favour was the wrong conclusion. And the Court of Appeal were correct, so to say. And that didn't involve any improper retrying of the case themselves. They simply established, as they were required to establish if they wanted to allow an appeal, that there were relevant flaws in the judgment. My Lord, unless there are further points that might feature in a judgment adverse to my client that I haven't dealt with, that Lordships have in mind and would like to ask me about, I think that's all I want to say.
Thank you very much, Mr. Rowe. Yes.
Thank you very much, Millard. I won't be long. The first thing that I would like to say is to make a correction. And that correction is that I had referred to the contemporaneous note in answer to Lord Stevens. And I had indicated that that note formed part of the paperwork that would have led to the charge being made. I want to correct that, because that note actually would have been written after the charge.
I'd understood that.
Oh, you understood that? Okay, good. And to be very, very clear from my own mind, the learned judge at page 180 of the electronic bundle, she was very concerned about how this charge was really instituted through the superior officers. And she asked this question. There was something that was asked. Now, I'm not quite sure if I got the note correct, so I want to get it clear. That was when counsel was asking you about your instructions to charge. Is it that you said that after receipt of your instructions, you submitted a file? Or is it that you said before the receipt of instructions, you submitted a file? And you say it's after the receipt of instructions. And the learned judge had made a very clear indication in her judgment that this issue about giving instructions to charge based on oral communication was something that needed to be looked at. So that the point that I am making, if I'm not coming across clearly, is that at the time that his superiors were advising or telling or instructing him to charge, it was on the basis of conversation and no recorded information that had been reviewed, considered, and a determination made upon it. So that's the first thing that I want to just place on the record. Now, secondly, dealing with my friend's point concerning the act, the Anti-Gang Act, and the evidence that could be used for the purpose of proving an offense under the Act, I can say from my recall that the evidence is definitely not hearsay evidence, and that there's a decision from the board of Cox which makes it very clear. In fact, there are two decisions from the board. I recall the name Cox in one, and my junior is looking at the other. Makes it very clear that evidence of gang activity needs expert evidence. A lot of detail. I wouldn't burden you with it. I can give you a citation if that is of any use. Yes? It is 2015 UKPC page 40. The case is Mayor's.
Sorry, number 40, do you mean? UKPC 40?
Yes, please.
Yes, okay.
And the judgment is really consolidated. It's Mayor's, Ragman, Cox against the Queen. It's an appeal from Bermuda. Same sort of definition of gang and gang-related activity. Now, so that I just want to make that clear.
You said that authority shows that you need expert evidence. I can't quite see why you'd need expert evidence. I mean, I could imagine situations where a police officer just observes gang-related activity and sees who's involved in it, but I can't see why that wouldn't be sufficient.
Well, from my reading of it and my recall of it, there's no difficulty in a police officer being considered an expert based on his own observation, note-taking, length of period of observation, and so forth. But the essential point that was made in the case is that it involves hearsay. It involves hearsay. And so that what you really need to have is a person who can give direct evidence. And that person, for the most part, I'm going from the top of my head with the judgment, for the most part, requires expertise as to the number of factors that need to be considered in relation to come to a conclusion that it is a gang in the first place. But perhaps my explanation is not the clearest, and it will be from the reference that I've made.
Thank you.
Thank you. Now, in relation to the matter, I've sought to make it clear that the intention to charge was an intention that had been made from the earliest. Whether the case will be proved or not too important right now. Charging, we need to get these people in one place where they could be kept. So that the issue is that the fabrication that is being spoken about in this case doesn't necessarily have to await the trial. The case was set up on a fabrication. And that is what I say explains what is called I think he called it his, what note he called it? Debriefing note. Now, apart from that, there have been exchanges in relation to how the judge's expression of conclusions have come about. It is my respectful view that based on the way in which the court has expressed itself, the court concluded that there was nothing that was believable, that there was no evidence that was available towards proving this claim, and on that basis, there could not have been an honest belief. Even by a most inexperienced police officer, that there was evidence that could have been led at the trial so as to have a fit case that was fit for trial. There was absolutely nothing. court has already as well, I referred to that in my submissions earlier, said that there was no shred of evidence. So that on that basis, there being no evidence, to use my friend's expression, it was simply to give hassle to the appellant that he is to be detained, and down the road, 120 days from now, we'll deal with whatever we have to deal with, whether a case could properly be proceeded or not. So that, in my respectful submission, is the improper misuse of the court process. It is the abuse of the legal system, and was the invocation of the criminal law for a wrongful purpose. It was not for the purpose of bringing a criminal to justice. The last thing I want to say is that my friend did indicate that what remained in relation to the possibility of having an honest belief was the question of the previous convictions. But the court dealt with that very frontally. The court made it very clear that previous convictions could not, especially in the context in which it was said, it cannot form the basis of reasonable suspicion that he was a gang member. You see, what has to be remembered is that it's not just a collection of people that will make a gang. It is a collection of people for a particular gang-related activity. So simply the fact that he had been convicted of a drug offense is not sufficient to move from simply a drug trafficker to now being a gang member trafficking drugs. Those are the matters I want to say in my reply, unless there's something that you could particularly seek to.
Did you say at the end of your submissions that you weren't seeking to uphold part of the damages award? I didn't quite take that on board.
Yes. In the appeal, what we have is that the Court of Appeal reduced the damages, okay, giving, I think, $50,000 for false imprisonment.
Yes.
What the learned trial judge had done is she had given a global sum, some $300,000, okay, for both false imprisonment and malicious prosecution. So that it is my respectful opinion that in relation, if the court is in favor of allowing the appeal, then we would be restating or reinstating the trial judge's order in terms of the malicious prosecution having been proven. And the damages that you would have awarded, now, you should now get those damages short of the $50,000.
Oh, because those have already been paid?
Yes.
I see.
That's the point I was trying to make.
I see, yes. So it's 300,000 general damages.
Yes.
Plus 50,000
exemplary,
Yes.
1,800 special.
But they weren't pursued, the special, were they? They've been abandoned.
Yeah, yes.
So it would be 350,000 minus the 50.
Yes.
Yeah. So I mean, I'm looking at paragraph 16 of the Statement of Facts and Issues, page 409. That says that the judge's order included the 1,800 in special damages. And did I understand you?
What page is
right?
that, please?
Page 409 of the electronic bundle. It's in the Statement of Facts and Issues.
I think in the Court of Appeal it was accepted that that could be upheld.
Could not be.
Could not be.
Yeah.
Is that right? Your predecessor, representing the claimant, did not try to uphold the special damages of the Court of Appeal. He accepted that those couldn't be.
Yes. So the exemplary, well, the court, of course, disallowed the exemplary because they said no malicious prosecution. So where we are is exactly where the Lord has indicated.
So just that we're absolutely clear.
Sorry.
So the 1,800 special damages is out on any view. You don't seek to restore that. The 50,000 exemplary damages you say would come back in
Would come back in.
if it's a case of malicious prosecution.
Yes.
And the 300,000 general damages, you say you've already received 50,000
Yes.
pursuant to the Court of Appeals order.
Yes.
So, but the balance of the 300,000 should be restored
Yes,
and
please.
paid.
Yes, please.
Thank you. Yes. Mr. Rowe, there was reference to one authority that was new to you, I think.
Oh, yes, the Myers
Fox, yeah,
case.
Myers case.
It's quite hard for you to deal with because we don't we don't have it at all, do
No.
we?
Well, I've taken the opportunity to read it at some speed during my friend's submissions while trying to listen to them as well.
If you're able to say there's nothing you want to add, so much the better. But if on a quick perusal there may be something you wish to add, I think Lord Leggett is right. We don't have it in front of us. Probably the better course might be to allow 7 days for you to put in any written submission, simply in
Yes.
reply on that.
Yes, perhaps we could leave it on the basis that if I want to say anything about it, then I'll have to do so within 7 days in writing.
Yeah.
My provisional view is I don't think I will, because I don't think that it addresses the questions that we're concerned with in this case.
For what it's worth, my impression was that it was unlikely to take matters further, but it's only fair that you should have the chance to look.
I think it deals with more general propositions about admissibility of evidence rather than with any analogue of Section 5.5 of the Trinidad Anti-Gang Act. But
Yes.
if I think of anything that I think you ought to be told on our behalf about it, and I'll do so within 7 days, of course.
Yes, thank you very much. Well, the board is grateful to counsel in this case. The board will take time to consider their judgment, and we will rise now. Thank you very much.